Welcome to Renter Rights 101, November 2023. My name is Barb Van Hoy, and I'm a policy analyst with the City of Colorado Springs Housing and Community Vitality Department. And it's my pleasure to welcome you to this community collaborative with lots of different organizations who work together to educate folks about renter rights in essentially Colorado, but sometimes a little bit in Colorado Springs. The reason that the City of Colorado Springs is part of this is that we really have an interest in reducing unjust evictions. We want to keep people housed. We want to reduce conflict between landlords and renters. And so the idea is to just create better education and understanding of folks to keep more people housed, because it's getting harder and harder. These events, as you can see from the slide, are organized in collaboration with Colorado Legal Services, Pikes Peak Library District, the Justice Center, the Colorado Housing Connects. We're excited to welcome the Community Economic Defense Project as a collaborator, and the City of Colorado Springs. Sometimes we have folks from Silver Key and the Independence Center as well. And you will briefly at the beginning hear from each of these organizations about the resources that they can provide to folks who might be in some kind of a conflict around their renter situation. And then the bulk of the evening will be our legal eagle, Clinton Albert, who is an attorney with Colorado Legal Services, and he will go through a very comprehensive review of the laws covering landlord-tenant rights in Colorado. As many of you may know, there have been a lot of new laws passed in the last couple of years, and I'm really excited and grateful to Clinton for updating the renter rights packet that we have available on the city's website at Renters 101, I think. Well, we'll put all the links in the chat. And also, if you're wondering if the slides and video will be shared, the answer is yes. Those will be sent out if you registered for this using the registration link, or if you signed up in person, or if you already subscribe to this our newsletter for Housing and Community Vitality. Those are all ways you can access the slides and the video, but we will also post them on the city's website on our Renters 101 Renter Rights Education page. So all of that will become available. Right now, this updated renter rights packet is available in English, and I'm hoping within the week we will have it in Spanish as well, but it definitely will be. We do not yet have next year's events like this scheduled, but we are planning to continue to do these, and we'll let everyone know in all the ways that we can on our website and our newsletter and all of that as soon as we have those scheduled. So I would love to start out with the resource descriptions by welcoming Deb Hamilton, who is the law librarian for Pikes Peak Library District Legal Resources. I need to switch to sharing. Yeah. Make sure to stay focused on the right thing. There it is.
All right, welcome everyone. Hi, my name is Deb Hamilton. I am the law librarian at Pikes Peak Library District. Our downtown location, the Penrose Library, we have a legal research collection that's free and open to the public whenever the Penrose Library is open. So if you ever need to access any of the laws or find other legal resources, that's a good place to start. What you see here on the screen is just our website here, where we have many of our legal resources highlighted. So you can always find this if you go into our website, and then the research section, you'll find a page for the law collection as well. And when you get on there, feel free, you're always welcome to contact me. You can email me, contact me by phone. And so then if there's something you don't remember from today, I can point you in the right direction or get you in touch with who you need to speak to. Just a couple things down lower on this page. You'll find contact information for many of the organizations you're going to hear from today, as well as where to find the Colorado revised statutes, which you'll hear Clinton talk about a bit in his presentation. So I'm not going to take up any more time, but please reach out if you need any help. I do have business cards over there, so please feel free to grab one. Thanks.
Do you want to just go ahead? And then I think I have Colorado Housing Connects on a tab up there.
How many people can I get to wait? There you go. Did it go through? I don't think it clicked.
It's just going slow.
Okay, I'll go ahead and start while it's going. So I'm Kathy Verdier and I'm with Colorado Housing Connects. We're a statewide housing resource helpline. We are funded by grants all over the state and by state organizations. We have information for seniors on aging in place. The helpline, we do anything from rental assistance, it's very little right now, utility assistance, affordable housing. Tomorrow night is our El Paso County Affordable Housing Zoom at the same time, 5:30 on Zoom, and the website didn't come, but if you pick up one of these and go to upcoming events, you will find that. We have a weekly workshop for affordable housing. It changes counties, but about 90% is the same throughout counties. We also do a lot on tenant, landlord, warranty, habitability, security deposit. And if you're from elsewhere in the state, Adams and Denver, we have free mediation for tenant landlord issues.
Sorry.
And there's flyers. So it's Colorado Housing Connects. Do you want me to give a number?
Yeah, go ahead.
Okay,
Do,
the number is 1-844-926-6632.
Hopefully that's the worst of the tech issues we have. Come on up, Laura from the Justice Center. We do have the website up.
Thank you. Hi, everyone. My name is Laura McKernan. I'm the Executive Director of the Justice Center. If you pass by that table, my flyer is the blue one. It's available in English and on the back in Spanish, just in case we have English or Spanish. Resources we have for you. The first one is called Find a Lawyer. In that one, you will find a free or a reduced cost attorney. And yes, that applies to landlords and tenants, depending on if you qualify financially for those resources. The second one is sometimes you just have a question, right? Like, am I doing this legally? What should I do? How can I do something? So you can call us in Wednesday nights. The phone number is 719-473-6212, and you'll find it on the website as well. It's like right at the bottom of the website. You'll find it. It's the same phone number. You call in Wednesdays from 7 to 8:30, and you get to talk to a Colorado barred attorney who can answer your questions. If you have landlord-tenant questions, a landlord-tenant attorney will answer that question. So it's somebody who has done this for a couple of years. I believe the volunteer that is landlord-tenant that's done it the least amount of the years has done it 17, so kind of knows what he's talking about. The other one has actually been in the community for over 20 years. So if you have a question, they'd definitely be able to answer. The last is resources we have called Learn with Lawyers. You can go online to see videos about different aspects of the law when it comes to landlord-tenant issues. Clinton is actually one of those videos, so you will hear him in person today, but he's also on those videos. We also have different toolkits online, eviction prevention toolkits. We have housing forms, warrants of habitability forms that you can find online for that. And for those, you can go to where it says educational tools, and it says sample housing forms or eviction prevention toolkit. So please feel free to roam around my website and grab one of the flyers in case you need us. Thank you.
Thanks, Laura. Come on up, Caitlin. And now we have Caitlin Schubert with the Colorado Economic Defense Project. So we'll talk about their services. Actually, did not call that.
Sweet, awesome. So as Barb said, my name is Caitlin Schubert. I am a senior program manager with the Community Economic Defense Project. It's always a mouthful, so you can just refer to us as CEDP. And so some resources that we have available. So we do rental assistance and mortgage assistance through the state. If you are at risk of eviction, so there are some eligibility, you do have to have a summons and complaint. Have not received ERAP in the last 12 months. And be under 80% AMI, which I believe is around 60,000 for Colorado Springs and El Paso. We also do mortgage assistance, and that's a little bit higher, and that's super applicable for folks who might own their own mobile home and owe lot rent. So if you're facing eviction for being behind on lot rent, we can also assist with our ENACted program, which can also provide utility assistance for folks who are behind on HOA fees, property taxes, utilities. You don't necessarily have to be in the process of foreclosure for that. We can assist with. Katie and I are in the back today, so if you are here and you're interested in seeing if you are eligible for rental and mortgage assistance, please come and speak to me. We also have a grant through the FCC for the Affordable Connectivity Program, which is essentially like a subsidy for broadband services. So if you're also interested in that, Katie's in the back. She can also enroll you guys today. And if you have any more questions about our programs, again, we're in the back. If you go to our website, go under Get Help, you can scroll down and see all of our intake forms. And if you prefer Spanish, you can go up here and change it to Spanish in the top, and it'll translate the website for you.
Thank you. Thanks for being here. All right, and now it is my privilege to introduce Clinton Albert. He is a housing attorney with Colorado Legal Services, and his entire caseload is landlord-tenant cases, and he has been doing this since 2019? 2018. Let me switch over to his presentation, and he can take over. Thank you, Clinton.
Thank you. So let's get. All right, good evening, folks. My name is Clinton Albert. I'm an attorney with Colorado Legal Services. Tonight, we're going to be covering a broad range of subjects. So at the top, I can appreciate and know that there will be questions, but I just have to ask that we hold them to the end. We will be covering a lot of material, so some of the questions may be answered in the presentation itself. But just to keep in mind that this presentation is for informational purposes only. These issues require a thoughtful analysis of both the facts and the law that would apply to the case. So if you are facing a housing issue, you may contact Colorado Legal Services for potential services and our potential assistance, excuse me. The contact phone number is listed down there, as well as our address. And you can apply in person between 8:30 and noon and 1 to 3, Monday through Friday. You may also apply online at our website at coloradolegalservices.org. So a few things to keep in mind before you move into the new residence. And one of the primary foundational things that I can really emphasize is to put everything in writing. If there is some kind of promise that's not reflected in the written lease agreement itself, put it in the lease agreement, put it in another section. Because if it's not written down, it's going to be a lot harder to prove. Also, a lease is a contract. This is going to be a binding document. You can have an oral lease, but it's going to be a lot harder to prove any terms of that lease because it's going to not be reduced to a writing. Also, oral leases are going to be presumed to be month to month, or however, with whichever frequency you may pay your rent. So one of the first things before we're into a place is applying for a new place. So the Rental Application Fairness Act has had a lot of changes this fall. We're going to be covering those in this section. So just generally speaking, landlords are not able to charge an application fee unless they use the entire amount to cover the costs in processing. These costs may be the actual costs in processing an application, or they may be an average of what it would take to process a batch of applications, multiple applications. Landlords are not able to charge different amounts to different applicants, and there must be a written disclosure for the anticipated or actual expenses necessary to run an application check. And they must make good faith efforts to return any remaining amount of the fee or fees to the applicant or applicants. So those were just some of the basic elements of the Rental Application Fairness Act. But as I indicated, there have been quite a few updates. Landlords are not, at this time, landlords are not able to ask about income except that it equals or exceeds 200% of the portion of the annual cost of the rent that is to be paid by the prospective tenant. Portion is an important word in that sentence there, because if you're a tenant who receives a housing choice voucher subsidy or you're a landlord processing that application, the portion refers to the tenant's portion. So if you're entering into a HAP contract with the housing authority as a landlord, then you're only able to inquire that the amount would be 200% of the tenant's portion. If you're an applicant applying with a choice voucher, the same thing would apply. You're only allowed to be asked about income to ensure that it meets 2 times the amount of your portion of the rent. Similarly, landlords shall not require that a tenant has income greater than 200% of the rent. Landlords are able to ask about income for the purpose of determining whether a tenant qualifies for a income restricted residence. Landlords are no longer able to ask about credit scores. I'm sorry, folks, I'm just trying to move the bar on my computer a little bit here. Are unable to ask about credit scores, adverse credit events, or a lack of a credit score unless the landlord is required to ask those questions by federal law to consider a credit score or a lack thereof. The penalties have also increased for the Rental Application Fairness Act. If a landlord does not follow the law, there are treble damages for the application fee itself, meaning 3 times the amount. Also, there are potential $50 penalties and then a $2,500 penalty if certain violations are not cured. Additionally, there's no requirement for a tenant to exhaust any kind of administrative remedies prior to pursuing a lawsuit for a violation of the Rental Application Fairness Act. So this is going to be while this is still in the law, it's been obviously very much narrowed by the recent updates that we just reviewed. So there's no consideration for any credit history that's 7 years or that's older than 7 years, in addition to the other limitations that we just reviewed regarding credit checks. What about criminal history? Arrest records, there's never a reason that an arrest can be used as a basis to deny an applicant, the arrest itself. If it is a criminal conviction, criminal convictions that are older than 5 years cannot be used as a basis to reject an application, except generally speaking, methamphetamine related offenses, not possession, but if we're thinking possession of precursor, possession with intent to distribute, manufacturing of methamphetamine, those type of larger scale offenses would be a basis to deny an application, regardless of its age. Any kind of convictions or offenses that require a person to register as a sex offender pursuant to Colorado revised statute. Any homicide related offenses, also stalking. One of the big updates in the last few months has been the addition of the portable tenant screening report. This is a way for an applicant to not pay any application fees by providing a potential landlord with a portable tenant screening report. So what does that mean? What is a screening report? It's going to be a consumer report prepared at the request of the applicant that includes information provided by a consumer reporting agency about the applicant, and the report's also going to have a date on which that information is going to be current. So what's the type of information that's included? You can see it on this slide here. Name, contact information, employment, income verification, last known addresses, rental and credit history checks for the applicant, and a criminal history record check for all convictions of a prospective tenant for each jurisdiction indicated in the consumer report. So other information about this, landlords are required to accept a tenant screening report, but they may require a few additional things in regards to this screening report. They may require that the report be completed within the prior 30 days, that it is made available directly to the landlord by the reporting agency or provided through a third-party website that regularly engages in the business of providing these reports and is compliant with state and federal law. The report is made available to the landlord at no cost to access or use in the rental application process. As a landlord, you do not have to pay to use this screening report. And similarly, as an applicant, you can use this screening report for a number of landlords to reduce the costs and application fees. Landlords may also require that a statement from the applicant that there's not been a material change in the information in the report since the report was generated. So just some other rules regarding this portable screening report. As a tenant, you do not have to pay any fees to use this. Landlords are not able to charge any application fees to use or access a screening report. And prior to taking any application in which there's going to be a fee expected or anticipated to process the application, landlords, you have to tell applicants, and if you're applying for places and you have a report, make sure that this is being said, then that is that as an applicant, you have a right to use the screening report. And if you provide a report to the then the landlord is not able to charge an application fee or charge a fee to use the screening report in processing the application itself.
Hey, Clinton, since
Yes.
this is new, we have some folks online who are asking very specific questions about those. I know we don't want to spend too much time with questions early on.
Certainly, and I will address these questions once we hit the end of the portable tenant screening report section. So this is the advisement that must be provided to potential applicants. It's got to be in at least 12-point bold font. If you run a website, put it on the website. That's easiest practice. If it's a paper or an online rental application, it also has to be in bold font. Or if you tell somebody verbally, then there has to be a written confirmation of receipt by the applicant of the advisement. So even if you tell them verbally, you then have to put it in paper. So best practice is just to put this in paper and just have it on the application itself. So while all landlords are required to accept a portable screening report, there are certain landlords that are exempt from these new laws. And that's landlords do not have to accept portable screening reports if they don't accept more than one application fee at a time for a unit. And they refund the total application fee within 20 days after written communication declining to enter into a lease agreement. So if you're a landlord and these are your business practices, this is the setup in which you would not have to accept a portable screening report. It seems to me that accepting the portable screening report, even if this would apply to you, would be an easier method of processing applications. Application denials, they can be in electronic form. However, if you are applying, you can request that be in paper form, and then that request must be honored by the potential landlord. So I'm going to go to the questions very quickly. I was curious how the new pet rent law worked. That law regarding breed restrictions, I believe goes into effect in January, and we will not be just covering that this evening. Can a landlord or property management company charge a monthly low credit mitigation fee? I would need to review that documentation. That is a new phrase for me. And I don't mean to be avoiding questions, but as I indicated at the beginning of this presentation, some of them are too specific and would require further analysis. I haven't had an apartment or landlord not ask for your credit score during the application process. If you don't provide it, then they won't consider you. So how can you get around this? If there is a violation of the Rental Application Fairness Act, if you apply for a residence, then the reason for denial must be put into writing. And if there is a violation of that Rental Application Fairness Act, and that is reflected in the written denial, then as a applicant, you would have the ability to send the landlord a demand letter demanding that the error be corrected. If that does not occur, then you would have the ability to pursue a lawsuit for a violation of the Rental Application Fairness Act with the new penalties that were just reviewed in a prior slide. Also, bank statements are asked for all the time to prove your income meets two to three times the income. So how can you prove your portion without showing them all of your income information? They are able to ask for income information to the extent that it would cover 200% of your portion of the rent. So again, on the credit score, is that for all applicants or just people on housing? Somebody is telling me that I am stating the law incorrectly. All right. I was told by multiple property management companies that they would charge a $25 a month because my credit score was below 650. And if it went back up above 700, I would have to reapply and repay to have the fee removed. That seems very peculiar to me, but this is a new addition to the law. So would recommend that if you want somebody to take a look at that further, you're always able to apply for CLS services. All right, so going back to the Rental Application Fairness Act, if an applicant submits an application and the landlord also obtains a consumer report, then the landlord also has to provide a copy of that report to the applicant and an advisement of the applicant's right to dispute the accuracy of that report with the credit reporting agency. Additionally, the Attorney General's office may independently initiate civil and criminal actions to enforce the Rental Application Fairness Act. So what happens if the application is denied? As I've hinted at, landlords are required to provide you as an applicant with a written notice of the application denial. It shall state the reasons for the denial, and the landlord has to make a good faith effort to return this decision to you within 20 calendar days of the decision to deny the application. As indicated before, this denial can be electronic. However, if you are applying and you request a paper copy, then that request shall be honored. So again, the penalties now include possible penalties up to $2,500 plus actual economic damages. As an applicant who has been wrongfully denied, you also must provide the landlord with a 7-day letter providing the landlord with an opportunity to cure the violation of the Rental Application Fairness Act prior to filing the action itself. If a denied applicant brings a meritless claim, then the applicant will be liable for a landlord's court costs and attorney fees in that type of action. So now that we've gotten through the application process, we've been approved, now it's time to sit down and go through the lease itself. So read the lease. Every letter, every sentence, every paragraph, every page, every addendum. If there is an addendum that is not referenced, or if there is an addendum that is referenced but is not included, cross it out. You don't know what you're signing, right? Because what you are signing is a legally binding contract. You want to make sure that you have a full grasp on all the terms in it. I don't care if it's 1 page or 100, read it all. If somebody is trying to force you into signing a 100-page legally binding document within 5 minutes, that's a red flag. So what are we looking for? What's the length of the lease? Month to month? Is this a 1-year lease, a 2-year lease? What happens at the end of the initial lease term? Does it roll over on the same terms and conditions automatically? Does there have to be a written agreement that's executed for a new lease term? Or does maybe a year lease automatically turn into a month-to-month lease? What about any potential fees in the lease that may be associated with the tenancy? What about responsibilities for upkeep and maintenance? And then where do you send notices if something goes wrong? There should be some kind of indication on this. If we're dealing with maybe a corporate landlord, there should be contact information for an agent to include where notices can be sent electronically, which is very important if we are dealing with a warranty of habitability situation. What about any rules or regulations? If those are referenced, make sure that you get a copy. If you're renting a single family residence and there are going to be maybe there's a homeowners association, request a copy of the homeowner association bylaws. Because if you're going to be subject to the rules, you want to make sure that you know what those rules are. Also, you want to check to see if your tenancy is regarded as an exempt residential agreement. We'll touch on that in just a second. Also, what about any appliances that are listed in the lease agreement? Appliances that are listed in the lease agreement are protected by the warranty of habitability. So that's an important lease clause to pay attention to, as well as what the email address, phone number, portal system is for electronic notice delivery. So exempt residential agreement, this comes into play on demands for compliances, and in that aspect, tenants have 5 days to come into compliance with the alleged violation instead of 10 days. If you're unsure of whether this applies to your tenancy, it has to be disclosed in the lease agreement itself. This only applies to single family homes, so if you're sitting there in an apartment or condo right now, it doesn't apply to you. It also only applies to single family homes that are leased by a landlord who owns 5 or fewer single family homes. Just very briefly, this is a rare situation that comes up, but if you are considering whether or not to enter into a contract which includes an option to purchase, I would very much recommend seeking legal counsel before doing this because it's more than likely going to be a large financial commitment. So you want to ensure that you have protection for building equity in the property and keeping equity in the property down the line. I don't really have much more to say on this matter. These are very fact-specific contracts. So I would just kind of, not to caution anybody against entering into them, but to make sure that you have a full appreciation of what it is that you're agreeing to. So as we're reading through the lease, these are going to be red flags. Well, they're not enforceable, so keep an eye out on them for them, but they can't be used against you because the law prohibits these lease provisions from being enforceable. As a tenant, you cannot waive your right to the return of the security deposit. You cannot waive the warranty of habitability, barring a separate agreement that is supported by consideration. I'll touch on that later. But just generally speaking, you can't waive it in the lease agreement itself because there has to be a separate agreement outside of the lease in which you lay out what portions of the warranty of habitability you are taking on as the tenant. You can't waive your right to the covenant of quiet enjoyment, a 5 or 10 day written demand for unpaid rent, the court process for an eviction. You also cannot waive late fees being capped at $50 or 5% of the late rent. Also can't have any lease clauses which assign an unreasonable liquidated damage from an eviction notice or action. Again, that's going to be unreasonable liquidated damages are going to be a case-by-case determination. So if you're thinking, what does that mean? Well, just generally speaking, it means a pretty unfair penalty for posting some kind of demand or notice on the door or filing an eviction case. Also, for attorney fees, attorney fees cannot be awarded unless they are disclosed in the lease agreement itself. Additionally, attorney fees can only be awarded if that lease clause indicates that it's what's referred to as a prevailing party clause, meaning who wins the case can request attorney fees. Finally, the attorney fees requested must be found to be reasonable by a judge or magistrate before they can actually be ordered. So the way to receive an award for attorney fees has not gotten more difficult, but there have been more steps that have been included in the process. So if your lease just says something to the effect of, if an eviction is filed, you agree to pay the landlord's attorney fees, that's not enforceable. The law also bans these lease clauses, prohibits them from being enforced. If they're included in a contract, they cannot be enforced in a court of law. You cannot waive your right to a jury trial with the exception of for possession of a dwelling unit. You cannot waive your ability to join any joint, collective, or class legal actions relating to the term of the tenancy. You still can't waive your implied covenant of good faith and fair dealing. You can't waive the covenant of quiet enjoyment. This is a very new one. Landlords are not able to charge fees for not providing a notice of non-renewal for the end of the lease, except for a landlord's actual damages. So it can't just be, you didn't give me 60 days notice, I'm charging you 60 days of rent. That's not, the law has changed. That is now limited to actual damages. You can't have any lease clause that characterizes any fees for utilities or services or any other payment under the terms of the lease as rent, except for the monthly payment for the occupancy of the premises. Rent means rent. It means that's the money you're paying for the roof over your head, not the third-party vendor fee, not the utilities, not the pet fee, not the storage fee. It's what's it called? What's the roof over the head? And that's going to be laid out in the lease agreement itself. There's also any lease clauses which would charge tenants a fee markup for a service for a third-party provider, except they may charge up to 2% of the actual cost or up to $10 a month, but not both. Voucher or subsidy providers are not able to pursue an eviction for non-payment of utilities. Leases must now include a statement that Colorado law prohibits income discrimination and also requires landlords to accept any lawful and verifiable source of money. This does not apply to landlords with 5 or fewer single-family rental homes and no more than 5 total rental units, including any single-family rental homes. Now that we've read through the entire lease, get a copy, right? Get a copy on the spot. It's a binding contract. You and your landlord just signed it. Or landlords, you and your tenant just signed it. Make sure you both have a copy. The best practice for everybody. That way you're both operating from the same set of information at the beginning of the tenancy. You each have a copy for your own records if there's ever a dispute. And additionally, the law requires that your landlord provide you with a copy of your signed lease within 7 days of you signing the lease. But what happens if after we sign the lease, ownership, management of the building changes? If the ownership remains the same, but the management changes, then the new landlord must provide you with updated contact information to include new address or addresses for any kind of notice. If your new landlord does not do this, then then I would recommend you contact the landlord for that information, because if it's February and your heat's out, you're going to want to know who to contact. If your building is for sale and your tenancy is jeopardized, you can record your lease with the clerk and recorder to preserve your possessory interest in the property. I would recommend seeking legal advice prior to doing this. That would result in placing any potential buyers on notice of your interest in the property, meaning, let's say you sign a lease, you have 11 months left on it, and the building is sold, or it's a single family residence and it's about to be sold. If you record that with the clerk and recorder, then that's going to put any potential buyers on notice that you as a tenant have the right to live there for the next 11 months or the remainder of the lease term itself. If you don't have any kind of current lease and your building is being sold and your tenancy is being jeopardized, then you may want to contact the new owner to propose a new rental agreement. Rent increases in the lease contract itself. It's going to lay out what the cost is. Landlords are not able to increase the rent more than one time in any 12-month period of consecutive occupancy, regardless of a written rental agreement, the length of the tenancy, whether it's fixed term, month to month, or an indefinite term. However, if there's a written contract, that's going to lock in that rental price for that contract period of time. So this is going to be, we're going to find rent increase issues more on month-to-month tenancies, verbal tenancies, things where we don't have that written guarantee for an extended period of time. And landlords may only increase rent upon at least 60 days written notice to the tenant. If it's not 60 days written notice, it's not a valid rent increase. The rent increase did not happen. Landlords may not terminate a residential tenancy with no written agreement by serving a notice to quit with the primary purpose of increasing the rent with less than 60 days notice. So I would view that as saying, here's your notice to quit. If you want to, you have to be out at the end of, you have to be out in 30 days. If you want to renew, your new rate is going to be X amount higher. That would be serving a notice to quit with the intent of avoiding the 60-day notice requirement. Late fees. So make sure that first of all, if your lease does not include a provision for late fees, you can never be charged late fees. Also, if your lease agreement has a late fee provision that is not enforceable by law, you can never be charged late fees. So landlords are not able to charge a tenant or a homeowner in a park late fee unless the rent payment is late by at least 7 calendar days. They can't charge late fees unless it's disclosed in the lease. That's a very basic, foundational element here. They can't charge more than $50 or 5% of the amount past due. Cannot require a tenant or a homeowner to pay the late fee unless that's disclosed in the rental agreement. Cannot remove or exclude a tenant from a dwelling or initiate a court process because the tenant fails to pay late fees. Can't terminate a tenancy because of the failure to pay late fees. Can't impose a late fee for late payments from a subsidy provider, and can't impose a late fee more than once a month, except that you may charge a late fee more than once a month so long as that total does not exceed $50 or 5% of the amount past due. You also cannot require any interest on a late fee. Can't charge a late fee unless the landlord has provided the tenant or the homeowner with a written notice of the late fee within 180 days after the date upon which the rent payment was due. And then any lease provision that does not comply with the late fee statutes, it's void, it's not enforceable, and a tenant may bring an action for injunctive relief. The landlord who violates this statute shall pay to the tenant a penalty in the amount of $50 for each violation. That's not just $50 per late fee, that's $50 per violation. A late fee can violate the statute in a number of different ways. So a landlord who violates the statute has 7 days to cure the violation. That does not alleviate the $50 penalty, but it does prevent further liability. And by further liability, what I mean is that if a landlord receives notice of the impermissible and illegal late fees and fails to cure them, then a tenant may bring a lawsuit seeking remedies such as compensatory damages. And then that second bullet point there is where the notice to cure comes in, because if you have been charged illegal late fees, you provided your landlord with notice and that has not been fixed, you may seek a penalty of $50 up to $1,000 for each violation. And that penalty would be payable to the tenant or the homeowner. You can also seek costs, including attorney fees to the prevailing party and any other equitable relief the court would find appropriate. It's also an affirmative defense against an eviction that the late fee statute was violated. A late fee is distinct from rent, and a rental agreement may not classify late fee as rent for the purposes of an eviction. All right, we've read through the lease agreement. We're about to move in. The truck, the vans, the boxes, they're all piled up outside, right? First thing we want to do though, before we start moving in and unpacking everything, is take pictures. Take the time to take pictures to document what the residence looks like at the beginning. This is going to be important, not right away, and hopefully never, but if you have a dispute at the end of the tenancy over your security deposit, you want to be able to show, hey, that nail hole that I'm being charged for, that was here. Here's the photograph that shows that when I moved in 3 years ago, this was still here. Take pictures of everything, whether it's damaged or undamaged. And then again, we'll talk about this at the end. You're going to want to take a second set of these photographs. This is really important documentation. And this is also, if you're in a security deposit dispute, this is evidence you won't be able to recreate after you move out. Also, if your landlord's amenable to it, I would recommend doing a walkthrough. That way you're both on the same page about, hey, everything's in working order. All the light switches are working, no burnt bulbs. The drains are all draining properly and in a timely fashion. It's not required to do this. The law doesn't require this, but I think this is a great first step to start off any kind of tenancy. You're able to enter the lease agreement with your landlord with the same understanding of any pre-existing issues in the premises, and also may be able to get a plan in place if there are issues that need to be fixed, how and when those are going to be fixed. This is not a place to be. I think that everybody should be critical in this stage, but not unreasonable, because this is a business relationship that you are entering into. This is a legally binding contract. You are paying money for this roof over your head. If there are issues at the beginning, make sure to place your landlord on notice of them. That way these issues don't snowball into something larger down the line. So again, it's a business relationship. I think it's best for both parties to have an understanding of what's happening in the property at the start of any tenancy. So let's move into the warranty of habitability. This is the promise that your residence is fit for you as a human being to live in. There's a list of things that must be present or must not be present. By law, that list is in the packet. We'll go through them as well in the presentation. Electronic notice. A work order is not a notice of the warranty of habitability, because a work order may say that you have a leaky drain, but it doesn't say that this has actually rendered your home uninhabitable pursuant to statute. There is a difference, and I do believe that judges will find there to be a difference. So you can certainly submit both. There's nothing saying that you can't do both, but best practice is going to be to submit a warranty of habitability notice. In the revised packet, there is a sample letter in the back of that to use as a potential template. Notice by email, portal, or communication system that is available to both a landlord and a tenant. There has been an update to the law. It used to be that you had to send it to the recipient identified in the lease agreement. However, that rule has become a bit relaxed in the new law, in the new statutes, and you're able to send an electronic notice in the manner that your landlord typically uses to communicate with you. So if we think about that, if the lease agreement says, here's our portal communication system, this is where you send your warranty of habitability notices, but you've been texting with your landlord the entire time. Well, text messages are how you normally communicate, so that's how you would send the electronic notice. If your lease is silent and doesn't have that provision on where to send an electronic notice, then same rule applies, and that's that you communicate with the landlord in the manner they use to communicate with you. You must retain sufficient proof of delivery of the electronic notice. If it's a text message, screenshot the text message and back it up. Save it in a Google Drive, save it in an iCloud Drive, save it in an Android Drive. I'm sorry, I'm an Apple person, so I don't know what the equivalent would be. Why is that? Well, one, you're required to do it, but heaven forbid you lose a phone and you lost your proof. So make sure to back that up. What are the conditions subject to the warranty of habitability? You have to have sufficient waterproofing and weather protection of your roof, walls, doors, and windows. Plumbing and gas has to be in good working order. You have to have proper hot water, proper fixtures, connection to sewage disposal systems. The functioning heating must be in good working order and in compliance with the law. Same with electrical, that's got to be in good working order and in compliance with the law. Common areas kept under control of the common areas under the control of the landlord must be kept reasonably clean. There must be an appropriate extermination in response to any kind of infestation. Bedbugs have their own kind of specific rules that we'll touch on here in just a second. Here's that second. Hear me? No sound. Sound is back.
Okay.
Great, thank you. All right, so if you're in your residence and you think, hey, I think I've got bed bugs here, as a tenant, you have to tell your landlord that. All right, so if you know or you reasonably suspect that, thank you so much, that the unit contains bed bugs, you've got to put them on notice. So landlords, you get this notice from your tenant saying, hey, I think I've got bed bugs in my unit. You've got to jump into action. This is not a tomorrow problem, this is a today problem. So within 96 hours of receiving that notice from your tenant, you have to provide them with 48 hours notice of your intent to enter the dwelling to do an inspection. You also must obtain an inspection by a qualified inspector. You may enter the initial dwelling unit. You may also enter, as a landlord, you may also enter contiguous units for the purpose of inspection, which to me makes sense because if one has it and you treat one unit and you don't look at the other units, well, you may be overlooking a problem. So if an inspection confirms the presence of bed bugs, then you have to inspect all the contiguous units as promptly as is reasonably practical. Landlords, you are responsible for all costs associated with an inspection for and the treatment of bed bugs. So after the inspection occurs, you must give your tenant written notice within 2 business days whether the unit contains bed bugs or not. If your inspector determines after the inspection of the unit that doesn't have anything, the contiguous units don't have any bed bugs, as a landlord, you must also inform the tenant that if their concerns remain, that they may contact the local health department. If the inspector does come back and say, hey, we've got a problem here, my inspection came back positive for bed bugs, then the inspector must provide that report to the landlord within 24 hours. And then not more than 5 business days after the inspection, you have to commence reasonable measures to effectively treat the bed bug presence. And that includes retaining pest control services. What this does not mean is you do not hand your tenant a can of Raid and say, have fun. That is not an effective treatment for bed bugs. You all are aware of that. So we've talked about what the responsibilities are of the landlord in response to a bed bug infestation, but tenants, you also have to do your end of things on this issue as well. And one of the main things is here is that you've got to comply with any reasonable measures to permit the inspection and the treatment of the unit for bed bugs. If there's typically a big long list of these are the things you got to do to get your place ready for us to come over and treat, you have to do them. So tenants, you're going to be responsible for the costs associated with preparing your dwelling or your home for the inspection and treatment. Going back to that hypothetical long list of things to do to prepare the residence, sometimes they will say you have to place all of your bedding in black bags and seal it off, or place your dishes in Tupperware containers. Those costs for those bags, for those Tupperware, that's going to be on you as the tenant. That's not your landlord's responsibility. It is important that you comply with that because as a tenant, if you knowingly and unreasonably fail to comply with the inspection and treatment requirements, you may be held financially responsible for the cost and treatment of any contiguous dwelling units if the need for treatment comes from you not following the rules. If a landlord knows that a unit contains bed bugs or has a pretty good idea that it contains bed bugs, you're not allowed to rent it. And then if a prospective tenant, if an applicant asks, you are required to disclose whether to your knowledge the unit contained bed bugs within the last 8 months or disclose the last date the unit was inspected for and found to be free of bed bugs. Landlords who fail to comply with the laws and procedures regarding bed bug infestations may be found responsible for a tenant's actual damages in that situation. Landlords may also apply for injunctive relief against a tenant who refuses to provide reasonable access to the dwelling or fails to comply.
Sorry about that. Should be back on now.
Hey folks online, can you hear us yet? Sound is back. All right, thank you. Where we left off there, or where it cut out, was what happens if as a tenant, you're not doing what you're supposed to be doing. You're not providing access to the unit. You're not complying with the reasonable request for inspection or treatment of the unit for bed bugs, and your landlord has to take you to court over that issue. If a court finds that you as a tenant have unreasonably failed to do what you needed to do for a bed bug infestation, they may issue an order granting your landlord access to the dwelling. the right to inspect and treat the dwelling, and requiring you as a tenant to comply with specific inspection and treatment measures, or assessing the costs and damages. That could get really expensive if there has to be multiple units treated because of the tenant's refusal to get the place ready for treatment. Unreasonable refusal. We're still in the warranty of habitability. We're still going through the conditions that must or must not be present. As a tenant, you have a right to an adequate amount of outside receptacles for garbage. If it's a single family resident, probably talking about a trash can. If we're talking about a 50-unit building, there better be more than one trash can. Also have a right to working floors, stairways, and railings. Locks on exterior doors, security devices on windows that open. The unit also has to be in compliance with all applicable building, housing, and health codes, which may materially interfere with your life, health, or safety. The unit must also be free from mold. A residence is uninhabitable due to mold when there is mold that is associated with dampness, or there is any other condition causing the residential premises to be damp, which, if not remedied, would materially interfere with the health or safety of the tenant. This does exclude the presence of mold that is minor and found on surfaces that can accumulate moisture as part of their proper functioning or intended use. Think shower tiles. Don't think bedroom closet. Appliances are also subject to the warranty of habitability. By statute, this includes refrigerator, range stove, or oven. Taking that out a step, we're thinking kitchen. The appliances that allow us to have a kitchen, which gives us which kind of is one of the key defining characteristics between a hotel room and a residence. Also, any other appliances that are listed in the rental agreement may be subject to the warranty of habitability as well. So, appliances specifically listed in a written agreement or otherwise actually provided by your landlord at the beginning of your tenancy. If the appliances go out and you make a demand based upon an appliance, if the appliance is replaced, as long as it has substantially the same features, it's not going to be viewed as retaliatory. The example I think about when I hear this is if you have a smart fridge with the LED screen and that breaks, and you wind up with a fridge like mine, it's still a refrigerator. It just doesn't have Bluetooth. So it's fine. It has substantially the same features. If, however, we go from a normal size refrigerator and then you roll in like a Yeti cooler, nope, that's not going to be sufficient. That does not have the same features as the original appliance. Also, this is more of a subjective condition subject to the warranty of habitability, and that's any condition that materially interferes with the tenant's life, health, or safety. This also significantly alters the time in which a landlord has to respond to the notice. So just because a residence is uninhabitable by statute, that does not necessarily mean that there's a breach of the warranty of habitability. So first, the residence has to be uninhabitable, and then the landlord has received reasonably complete written or electronic notice of the condition and has failed to start fixing the problem within the required timelines. This situation, that's when we get to a breach of the warranty of habitability. So, when does your landlord have to start? Commence remedial action, fix the problem. There are 3 different timelines to think about here. Condition that materially interferes with your life, health, or safety, that's a today problem. That's within 24 hours. So that's when I indicate that that's significant, that is significant when that type of condition is alleged. When it's one of the other conditions that we are going through, trash cans, windows, electrical, plumbing, heating, within 96 hours, but only if a tenant provides written permission to enter to commence repairs. If you look at the sample letter that is in the packet, you will see that, I believe it's the last sentence that I wrote onto it, is I give my landlord permission to enter the unit for the purpose of commencing repairs. If you don't include that, there has been a Colorado appellate court decision this year that has indicated that the landlord was not in breach of the warranty of habitability because the tenant did not provide that express permission. Mold has its own timeline. It's in the slide. There's a lot more steps to mold. I'd like to keep moving through the presentation to also get to have a longer time for questions this evening as well. So here's the timeline for mold. As you can see, it's much more detailed and a lot different than simply 24 and 96 hours, given the amount of benchmarks that must be met to start fixing the problem. So once you provide that notice, that demand to your landlord, they do have to respond. So landlords, you do have to provide a written response, not a phone call, something in writing. So within 24 hours of receiving the notice, you have to provide your tenant with a written response. And this is also, this is extended up to, this time, 24 hours is extended up to 72 hours if the premises is inaccessible because of damage due to an environmental public health event. These were laws that were passed in the wake of some of the very destructive fires over the last couple of years. I believe the Boulder fire was the most recent one I can think of. What has to be in this response? So you get this. So as a tenant, you send your notice off. Landlord, you receive it. You've got to write back to them. You've got to tell them how you're going to fix the problem. You have to tell them when you're going to start fixing the problem, and you have to give them an estimation on how long is it going to take? How long is it going to take to fix this problem? This last bit here is relates back up to environmental public health event. Proof of filing an insurance claim is not proof of remediating the problem. That just means you sent paperwork off somewhere. It doesn't mean that you picked up any drywall, lifted a hammer, did anything to fix any problems with the place. Is there ever a situation in which a residence is so uninhabitable that as a tenant, you have a right to an alternate residence? Yes, there is. If the residence is in a condition that materially interferes with the tenant's life, health, or safety, and the tenant makes a request, then landlords, you have to provide a comparable dwelling unit or a hotel room as selected by you, the landlord, at no expense or cost to the tenant. Landlord's not responsible for other costs that arise after the relocation period. Tenants, you're still responsible for rent during this time. And again, this only applies to material interference with life, health, or safety. If we're going through the process in the right fashion, then we should have an idea of how long am I going to be displaced in this alternate residence, because my landlord has given me my written notice, my written response saying this is how long we anticipate it'll take to fix the problem. So, tenants, what happens if you sent the notice off, you don't get a response? You get a response, but the work doesn't start. What can you do then? You can terminate the lease. If there's no remediation, at least 10 days after the notice is provided, but less than 30 days. If it's the natural disaster event and the landlord can't fix the problem within 60 days and cannot provide alternative housing, you can terminate the lease in that situation. You can obtain injunctive relief in the county court or district court. Injunctive relief in this situation would be the court ordering the landlord to make certain repairs, and also may order that the rent value that the rent be lowered while the property is in an uninhabitable state. As a tenant, you can also defend against an eviction for non-payment of rent. There's also other monetary options such as set-off that we'll touch on, but I won't really go into detail with. It is a very detail-oriented process. I'm sorry for the repetition of my words. So with the warranty of habitability, if there's a breach, one of the options is to withhold the rent. And this slide isn't entirely accurate, and I apologize for that. But if a person is not found to be indigent for the purposes of the warranty of habitability, they will need to pay the amount withheld to the court to defend themselves against an eviction for non-payment. Would recommend seeking legal advice before taking this step, because if there's a problem with the notice, then there may be a problem with the withholding, and it may lead to an eviction because the paperwork wasn't proper. Also keep in mind that tenants can bring an outside claim for breach of an additional lawsuit separate from an eviction alleging a breach of the warranty of habitability. The other monetary option, this is the set-off that I was describing, it's deducting the cost of repairs. This is a specific process with competing estimates. It does not apply to everyone. You cannot deduct for certain issues. So again, I would seek legal advice before taking this action, because the tenant wrongfully deducts rent, and the landlord can get a money judgment in the amount withheld, and the tenant may be evicted for non-payment. If it's a bad faith deduction by the tenant and the landlord takes them to court, it's an automatic eviction and then a money judgment for 2 times the amount withheld. Are there exceptions to the warranty of habitability? Yes, there are. This was touched on at the beginning when we were going through unenforceable lease provisions. But if there's a separate written agreement signed by both parties, supported by adequate consideration, think money, then, and the tenant has the skills to perform the work. If you're renting to an electrician, you may be able to create a separate agreement where your tenant would be responsible for the electrical work in the home, what that would then mean. And then if there's an issue with the electrical, as the landlord, that would not be a condition subject to the warranty of habitability. Again, this can't be a handshake deal. This has to be done in writing. This has to be separate from the lease agreement. It has to be signed by both parties. The tenant has to have the work to do this skill, and it has to be supported by adequate consideration. So again, if you're unsure about whether this applies to you or your tenancy, I would recommend seeking legal advice. This is not specific to evictions, obviously, because we're talking about collections, but it is a defense against a collection action that there was a breach of the warranty of the habitability. So, like I said on the prior slide, it wasn't entirely accurate, and that is that the amount of rent withheld in a warranty of habitability out type of case, if there is an eviction filed for non-payment of rent, if there's now required to be a hearing to determine whether or not the tenant is indigent pursuant to the warranty of habitability. If that is the case and the court finds them to be indigent, this is a different indigency standard than Colorado Legal Services has. So I am not great with this off the top of my head. But if a court finds the tenant to be indigent, then it will not require the tenant pay a bond to raise the warranty of habitability as an affirmative defense against an eviction for non-payment. This is what it means to be indigent for the purposes of warranty of habitability. I'm just going to move to the next slide. This is available in the slides, so please, if you want to refer back to this at a later time, I would recommend providing your email address so you get a copy of these after tonight's presentation. So now we're in a hearing on a case where the warranty of habitability is an issue. The court is required to determine the reduction of a place's rental value in its uninhabitable state to the date of the trial. Then in the hearing itself, if the tenant's able to prove that the non-payment was because of the breach of the warranty of habitability, the court shall deny possession to the landlord and shall deem the tenant the prevailing party. The tenant then has to pay the rent that has accrued to the date of trial, taking the reduction of value into consideration. So if your rent's $1,000, you withheld it for 3 months, you're in court over a $3,000 allegation of non-payment, and the court says, well, find that 50% of the rental value is not here because the home was uninhabitable, then we're looking at $1,500. So as the tenant, you would have then 14 days to make that reduced payment into the court registry. Or to the landlord or to your landlord. If, however, you don't do that, you don't make that payment, then the court reverses itself. The court then awards possession to the landlord if you don't pay the reduced rent within a 14-day period. Court may also order the landlord to make repairs and to correct the uninhabitable conditions, and may order that the rent stay at that lower level, at that reduced rate, until the repairs are completed. If the court does order repairs, then the court retains jurisdiction over the case until the repairs are completed and the court's orders have been complied with. Retaliation. Essentially, if Landlords are not able to retaliate against tenants for making a good faith complaint regarding the warranty of habitability to the landlord or to a governmental agency, think health and building, think code enforcement, or organizing or becoming a member of a tenants association or similar organization. What does retaliation include? It includes increasing rent or decreasing services, terminating a lease without the tenant's consent, except as permitted by law, bringing or threatening to bring an action for possession, essentially threatening or trying to evict somebody for making a good faith complaint, or taking an action that intimidates, threatens, discriminates, or retaliates against a tenant. If you are a tenant, timing alone is not going to be sufficient to prove a claim of retaliation. There are some other resources to consider. If you are dealing with uninhabitable issues, because as indicated, tell your landlord, put them on notice as well, but there's nothing preventing you as a tenant from reaching out to local organizations, local code enforcement, the Department of Health, to report any habitability issues with the residents as well. Keep in mind, these agencies are not in place to enforce the warranty of habitability. For example, code enforcement enforces city building code, court enforces the warranty of habitability. There are sections of overlap, but they are not identical. For example, code enforcement does not have any mechanisms for mold enforcement. And the reverse of that is code enforcement requires screens, whereas the warranty of habitability does not require window screens. So again, this is just kind of a little bit more of what I was just reciting, that code enforcement does not have the ability to enforce the warranty of habitability. There's a lot of overlap there, but it's not 100%. All right, going into security deposits, the big update from 2023 is a security deposit cannot be greater than 2 months of rent. So when can your landlord keep your deposit? They can keep your deposit for damage beyond normal wear and tear, non-payment of rent, abandonment of the residence, non-payment of work contracted for the unit by you as the tenant. So what's normal wear and tear? It's the usual deterioration of the living space from living. What's not normal wear and tear? Whoops. Oh boy. Intentional and careless destruction of property. Careless or intentional destruction of property. If you punch a hole in the wall, that's not normal wear and tear. So we've hit the end of our tenancy. We're moving out. What do we do? Clean the residence. Also, this is where you want to go back through your lease agreement. What did you agree to clean in the lease agreement? One of the things that I think, at least I know I overlook this, is oven cleaning. It's annoying. It takes time. It's going to take time for you, or it's going to take time for somebody else. The question is, do you want to pay for somebody else's time on that? All right. So make sure that you clean it. Make sure also, see if your landlord would do another walkthrough with you. Take more photographs. Go back and look at the photographs that you took when you first moved in and try to take those same photographs from those same angles, showing what happened over time. Make sure to return the keys. Also make sure to provide a forwarding address. In regards to security deposits, your landlord has, by law, up to 30 days, but most leases have it written in that it's up to 60 days to return the deposit or the accounting statement. However, landlords are only required to send that deposit, send that statement to the last known mailing address they have for you. Well, if we think about this, if I just moved out of a place and I don't tell you where I moved to, the last known mailing address you have for me is the place that we both know I don't live. So give a good forwarding address. It just has to be a mailing address. It doesn't have to be a new residential address. Sometimes things are in flux as we're getting settled into a new phase of life. So if you have a friend, a family member that would be able to, accept your mail or PO box, those are all acceptable. However, you must provide that information to your landlord, or they're fine with just sending the accounting statement to the place you just moved out of. So what happens if your landlord does not return your deposit, only returns part of it, and you disagree with the reasons for the withholding? We're going to have to send a demand letter. There are some sample letters in the back of the pack, one for each situation, one where you get no return and 2 where you're disputing the reasons of the reasons for the withholding. So you send the demand letter. I have certified up here. With every passing day, certified mail becomes less and less of a value because we send them PO boxes. They attempt to have it signed multiple times, and then a month and a half later, you get your letter back undeliverable. So I would recommend sending it with tracking. That way you can see when it was delivered. Also, you want to keep a copy of this letter because that's going to be, if you find yourself in court, that's exhibit 1 of here is the demand letter that I sent. Sorry, probably exhibit 2. Exhibit 1 is probably the lease. Here are the sample letters. And again, these are in the packet as well. There's no magic wording here. You just want to make sure that you very clearly state what the issue is. You can see on sample letter 1, that's giving you an opportunity to dispute the reasons for withholding and lay those out. The second letter is for folks who didn't receive anything within 60 days. And to be clear, if you have not received anything within 60 days, after that time period has expired, you get your full deposit back. Landlords, you had 60 days to figure out what was going to be withheld. If you didn't do it within the 60 days, you have forfeited the ability to withhold any portion of the security deposit and are required to send the entire amount to your former tenant. You may receive a partial refund with some kind of restrictive endorsement or some kind of accord and satisfaction language, which indicates that acceptance of the partial refund constitutes a full accord and satisfaction of the security deposit, or that this is a full resolution of this dispute. Just be careful of any type of language in that fashion. If you do see that language, that's where you want to seek and you're not sure what it means, seek legal advice, seek legal counsel. So if you don't receive a response to your demand, we still don't have the security deposit, we don't know why it's being withheld, or it's being withheld for reasons that are not permitted by statute, then you can initiate a small claims action if the amount is under $7,500. You can also initiate an action in county court up to $25,000. There's no kind of smaller amount. I start with small claims because that leads to it's a more expedited process. As a tenant, you can seek treble damages if filed within 1 year and the court finds that the wrongful withholding was willful. So if the landlord deliberately fails to return the security deposit during the additional 7-day period, the retention is logically willful under this section. And that's from, you can see the case site there where that language is pulled from. That's Turner v. Lyon. That's about 50 years old, but still good law. So we're at the end of the lease, but sometimes the end of the lease isn't what we thought it may be. It's not at the actual end that's in the contract, and we want to terminate the lease early. So some leases have language in it to permit the early termination of the lease. That does typically involve some kind of payment. If there's a breach of the warranty of habitability, that may allow you as a tenant to terminate the lease early. There's also an ability there are also additional protections for victims of domestic violence, abuse, stalking, or unlawful sexual behavior, where they may terminate their lease upon providing proof to their landlord of them being a victim of these acts, and they are able to terminate their lease with no penalty. Military orders, act of God. And the act of God, that's so long as it was not caused by your negligence. For example, if you cause a fire, that's going to be a problem. But if lightning strikes, then you may be able to terminate the lease early without any further contractual obligation. Additionally, while you can terminate your lease if your landlord breaches the warranty of habitability, you can also terminate your lease if there are multiple uninhabitable conditions. So if the same condition within 6 months renders your residence uninhabitable, the heat goes out twice, the electric goes out twice, then you can just terminate your lease. You can do so on a 14-day notice to the landlord. It has to be in writing. 14 days notice, that's necessary to terminate it. The exception here is you cannot terminate your lease early if your fridge goes out twice. So the appliances are not part of this, of the multiple warranty of habitability conditions. Moving into the Mobile Home Park Act, there are additional rights for tenants in mobile home parks who own their homes, and they have the right to a written rental agreement. The termination of the tenancy must be for cause. Since we do have the additional property interest of home ownership, homeowners can't just receive a notice to quit. There has to be actual cause to terminate the tenancy. There's a 90-day cure period for demands as opposed to 10 or 30 days if it's a CARES Act property. Notice to quit, 90 days to move or sell the home. Security deposit can not be greater than 1 month lot rent. Park management has to adequately disclose the terms and conditions of a tenancy in writing in a rental agreement to any prospective homeowner. And the disclosures must include the day that unpaid rent is considered in default. And that's to set up when a late fee may be charged, because as we reviewed earlier this evening, a late fee can only be charged if the rent payment is 7 days late. So the lease agreement has to state this is when your rent's due in order to calculate out when the late fee can apply. There has to be a name and address where a manager's decision can be appealed, and all charges to the homeowner other than rent, including late fees. These all have to be disclosed in the written rental agreement for homeowners in a park. So what constitutes cause for an eviction? And again, there's a long list here. I'm going to keep moving forward. This list is in the slides. It's also going to be in the packet as well. Rule changes in a park. If a homeowner, if you agree to the rule changes, they go into effect immediately. If you don't agree, they go into effect 60 days after. As a homeowner, you have a statutory right to privacy in the park, and that's that management has no right to enter your home without first obtaining your written consent. They can only do so to carry out statutory duties or in the case of an emergency or when the home has been abandoned. And that you can, as a homeowner, you can revoke your consent at any time. The notice must include the date and the approximate time of the planned entry, and it has to be served, delivered in a manner reasonably likely to be seen or heard by that resident in a timely manner. If you walk up and you slip it under a doormat, well, you know no one's going to be checking under the doormat. So again, just don't try to hide it. The Mobile Home Park Dispute Resolution Act, we really don't have the time to get into this tonight. This is an administrative process that provides park management and homeowners an opportunity to resolve disputes in a park regarding the tenancy without going to court first. The Division of Housing oversees this program. This reflects the unique nature of homeowners in the park because they own the home and they're renting the lot. So a lot of these homes may not be able to be moved. So an eviction kind of operates as a foreclosure. So this is an additional safeguard built into the law to protect homeowners in a park and to protect their equity in their homes. And also to facilitate better relations between management and tenants. So again, I'm not going to be going through this tonight. I'm trying to get us to questions here. So these are, this dispute process is laid out in the packet and in the slides. This has been a significant update as far as a homeowner protection. So landlords shall not make any oral or written statement threatening an eviction for reasons that are not grounds for terminating a tenancy in the park. Parks who violate this law may be, for a groundless threat, may be liable for up to $20,000. So that is a pretty significant cause of action that is available to homeowners in a park if park management makes a groundless threat to terminate the tenancy. Additionally, if a park intends to change the use of a park, there's now protections for homeowners in the park to include payment of relocation costs within a certain distance, also the purchase of the home for $7,500, $10,000, or 100% of the fair market value, whichever is the greatest. Parks are not able to increase the rent on homeowners if they do not have a current active registration filed with the Division of Housing, if there are any unpaid penalties owed to the Division of Housing, and they've not complied with any final agency orders issued by the Division of Housing. This is where the Dispute Resolution Act can come back into effect in other areas of a homeowner's tenancy in a park. Any rent increases issued in violation of the Mobile Home Park Act are invalid and have no force and effect. Landlords are not able to charge homeowners or residents a fee to meet in common buildings or spaces in the park, except for any reasonable cleaning fees or damage costs. Landlords shall host and attend a meeting for residents of the park if requested by a homeowner or resident. This is a prohibition against retaliation or intimidation for organization activities by homeowners in the park or creating a homeowners association. Parks cannot coerce or require a person to sign any kind of agreement. Management is not able to require a homeowner to sign a new lease or agreement in violation of the Mobile Home Parks Act or to mislead a homeowner about the obligation to sign a new lease agreement. Rules regarding accessory buildings and sheds are now presumed to be unreasonable. And there is an exception. The exception is laid out there, but just generally speaking, rules and regulations can no longer regulate accessory buildings or sheds for homeowners in a mobile home park. New homeowners, however, may be subject to rules that were not enforceable against prior homeowners. If I want to use a broad umbrella term here, there's now kind of a grandfathering effect for some of these rules where old homeowners are going to not have to follow the rules where new homeowners in the park will. There's also new restrictions on management's approval, potential approval of a new applicant. There's new notice requirements for selling a park, new notice requirements for bilingual homeowners and residents for selling a park. There's also an expansion of the homeowners and residents' right to pursue a civil action. There's updates to the dispute resolution process. There's more requirements in regards to record keeping for parks. And again, I'm just briefly touching on this because of all the subjects we haven't gotten to tonight, we still haven't gotten to evictions. So forcible entry and detainer is the procedure for evictions in Colorado. Landlords have to use the court process. They cannot do self-help evictions. If that does occur, then there's a lawsuit for an unlawful eviction. There are reasons a landlord can initiate an eviction action. They are laid out in the packet, as there are more than just. There are some unique situations that do come up. This has been one of the biggest additions to the law this year. And that is the addition and development of mandatory mediation. So this is intervention in dispute negotiations by a trained neutral third party, and it's to try to assist the parties to reach their own solution prior to filing an eviction case in court. Really, the parties are bound by their creativity at a mediation. You can come up with a payment plan, come up with additional rules for the tenancy, an extension of a lease, just figure out a way to solve the problem. So for certain tenants and certain landlords, Colorado now requires that the parties attend mediation before a case can even be filed. So who's eligible for mediation? A tenant is eligible for mediation if they receive SSI, SSDI, or TANF, and the tenant discloses in writing to their landlord that they receive such assistance. Landlords that are required to mediate, all landlords are required to mediate unless, there are a couple exceptions here, the landlord is a 501c3 nonprofit that offers opportunities for mediation to residential tenants prior to filing a residential eviction in court. My inflection raised there because offers opportunities, not just the existence as a 501c3, but a 501c3 that offers opportunities for mediation to tenants prior to filing an eviction in court. Or you're a landlord that has 5 or fewer single-family rental homes and no more than 5 total rental units, including any single-family rental homes. So all landlords except those two types are required to participate in mediation. The process begins prior to receiving a summons and complaint, and arguably could begin prior to receiving any demand or notice. Landlords are required to ask tenants if they receive SSI, SSDI, or TANF. landlords, if you do not ask this, and you run into me in court, I will be yelling that you did not follow the law and the case is required to be dismissed. You have to ask. So you have to ask in writing. And verbal questions do not count. Tenants must respond in writing that they do receive the assistance. Failure to respond in writing waives their right to mediation. So what about the cost and scheduling here? There is no cost for tenants. Landlords, you are responsible for your share of the mediation costs. You are not able to somehow shift that cost over to your tenant. The scheduling of mediation, this must be conducted by a trained third party. The Office of Dispute Resolution shall schedule the mediation for the first available date, no later than 14 days after the landlord's request for mediation. Here locally, if you go onto ODR's website, there's a special little link for landlord-tenant ODR scheduling, mediation scheduling. So this is a kind of a separate scheduling process. ODR is going to have a longer time than 14 days. That's why I point out that there is that separate little special tab for the landlord-tenant scheduling. If you're having issues scheduling that, just call them. I don't have their number. I wish I had that right now, as I say that sentence out loud. Mediation can't be waived. So this is one of the new lease clauses that cannot be enforced, and that's any kind of waiver of mediation. So we've now gotten past the mediation process. All right, so there's been the written inquiry. Tenants, we've responded saying, hey, we received this assistance, we've gone to mediation, and unfortunately, we haven't been able to reach a resolution. We haven't been able to fix the issue. So now, maybe this happened before the mediation, maybe it happened after, but the first step in an eviction case is going to be receiving the notice to quit or a demand for compliance. I apologize if you're screenshotting this. The demand for compliance is not a valid demand for compliance because it does not contain the required statement regarding mediation, which we'll get to here in just a second. You don't have to use any specific language except the required language. And the state form is not required. However, the state form does include the required language. It has to describe the property, the date of the termination of tenancy. It has to be signed by the landlord. It also has to state the time which possession shall be delivered. And it must be served by statutory deadlines. Month-to-month tenancy requires 21 days prior to the end of the applicable tenancy period, not just 21 days from when you serve it. So if you receive a demand for compliance, if you receive a notice to quit from your landlord, what kind of action should you take? For demand for compliance, for non-payment, contact Catholic Charities, local agencies for potential rent assistance. You can also contact your landlord to attempt to work out a payment plan. Or if you receive SSI, SSDI, or TANF, you may just want to disclose that to them as well. That way the mediation would be scheduled. For other violations, for non-monetary violations, too many pets, too many people, something in that type of area, you can provide your landlord with documentation that the violation did not occur, or provide documentation showing that while it did happen, the problem has been fixed and you are back in compliance with the lease agreement. For a notice to quit for substantial violation, this is going to be guns and drugs, behavior that endangers the person or substantially endangers the property, violent or drug-related felonies, a crime which carries a possible penalty of 180 days and has been the basis for the residence to be declared a public nuisance. So if it's a substantial violation, if you have any way of providing documentation showing that that did not in fact occur and you did not in fact commit a substantial violation, that may be useful to provide. Keep in mind that you are responsible for the conduct of any guests as well. Notice to quit for repeat violation. This is where there has been a second violation of the lease within 12 months. If you can provide your landlord with documentation showing you did not violate the lease provision a second time or the first time, that may be able to resolve the dispute without going to court first. If you get a notice to quit, check your lease, make sure it complies with the notice to quit. make sure it complies with your lease, complies with the law. If you may need more time, you may want to contact your landlord to maybe request an extended move-out date. And if that doesn't happen, then it may be time to prepare to move out of the residence. So I know the slide a couple slides ago said there's no required language, don't need a state form. For demands for compliance, this statement here must be included. And that's the statement regarding the potential right of a tenant for mandatory mediation. And again, this language is reflected on the most recent JDF forms for demands. So the state form does have this language included in it. So the notice or the demand has expired. We're now on to the summons and complaint being served. The summons, it has to contain a list of available resources. It has to have a copy of the blank answer form and a form that allows either party to request all documents in the landlord or tenant's possession relevant to the current action. It has to include a statement regarding a tenant's right to cure non-payment of rent up until a judge enters a judgment for possession. Additionally, the summons must include a signed affidavit indicating mediation occurred and was unsuccessful, why mediation did not occur, either due to the tenant or due to the landlord. A summons and complaint may be served by personal service or by posting and mailing if no one is at home at the time service is attempted. If it's served by posting, as a landlord, you can only receive a judgment for possession. You cannot receive a judgment for damages. As a tenant, if you appear on the return date or you file an answer into an eviction case for non-payment, you have to waive the personal service requirement, and the court has jurisdiction to award your landlord a monetary judgment in that situation. The summons, you have to do one of three things: reach a settlement agreement, do nothing, or file an answer. If you do nothing, you will likely be evicted. Generally speaking, I advise against that. There are exceptions to that. If you think you're one of those exceptions, contact CLS. So in an answer, you're going to include your legal defenses against an eviction. It is due by 5 p.m. on the date listed on your summons. In El Paso County, our return dates on the summons are non-appearance dates. So if you go to the courthouse on the date listed on your summons, you're not going to find a judge to talk to. You might find somebody from CLS over in our little courthouse clinic, but you will not find a courtroom. It will also say on your summons, non-appearance. It's very confusing, I know. So that's why we're talking about it now. If in your answer, you are claiming that you've received an improper notice or an improper demand, you must raise that in an answer in the defense. You cannot bring that up for the first time at trial. And then the trial shall be set by the court 7 to 10 days after an answer is filed. That's assuming the court has the availability in its schedule. Between the filing of the answer and the trial, the court shall order that the landlord or tenant provide any documentation relevant to the current action. During non-payment of rent, so if we're dealing with a non-payment, landlords, you are required to accept the tenant's full payment of all amounts due according to the notice, as well as any rent that remains due under the rental agreement until a judge issues a judgment for possession. This can be paid either to the landlord directly or deposited into the registry of the court. Once a court confirms that the full amount has been timely paid, the court shall vacate any judgments that have been issued and dismiss the action with prejudice. Failure to attend mediation is an affirmative defense. If the mediation laws were not followed, that is a defense against an eviction. The warranty of habitability is a defense against an eviction. And folks, I'm kind of going fast now because I'm trying to get to questions. We touched on this a little bit earlier, and that's the attorney fee update, that attorney fees must be a prevailing party clause in the lease itself. The court must also then determine who the prevailing party is and that the requested attorney fees are reasonable. Make sure to appear at your return date. By appear, I mean file an answer, file a settlement. If you don't, there's going to be a default judgment. And then we're in writ of restitution land. So writ of restitution is what allows law enforcement to enforce the judgment for possession. More simply put, this is what allows the sheriff to come into the residence, remove you from the residence, and give the keys back to your landlord. This can be issued 48 hours after the entry of a judgment for possession. However, law enforcement cannot use this until 10 days after the judgment or 30 days if you are a tenant that receives SSI, SSDI, or TANF, and the judgment is not based upon a substantial violation. So if you had a right to mandatory mediation at the beginning of the case, you go through everything, and unfortunately it ends up in an eviction, you have an additional month to move based upon that source of income. So again, this is the 30-day writ of restitution. Again, the exception here is substantial violation. Also, landlords with 5 or fewer single-family rental homes and no more than 5 units, including any single-family rental homes. Unlawful removal or eviction. If you don't go through the court process, there's a minimum $5,000 lawsuit that you're facing, or 3 times the monthly rent, whichever is higher, plus actual damages. A court may also award possession back to your tenant that you illegally evicted. Fair housing is the prohibition of bans discrimination based on race, color, disability, sex, sexual orientation, including transgender status, national origin, national ancestry, religion, creed, marital status, and or familial status. In Colorado, also there is income discrimination. The exceptions here are owner-occupied buildings with 4 units or less, single-family housing sold or rented without the use of a broker, or housing operated by organizations and private clubs that limit occupancy to members. Like I just said, there's a prohibition based on, you cannot discriminate based on source of income. And that means that you must accept, landlords are required to accept income derived from a lawful profession or occupation, and any income or rental payments derived from any government or private assistance grant or loan program. Very quickly, service animals are covered by the Americans with Disabilities Act. They are a medical device. That's it. It's the same thing as a nebulizer, same thing as an oxygen tank. Emotional support animals, also service animals, can only be a miniature horse or a dog. Emotional support animals are not explicitly protected by the Americans with Disabilities Act. However, they are still subject to fair housing protections, and tenants are able to make reasonable accommodation requests for emotional support animals. What is a reasonable accommodation request? A reasonable accommodation request means that you're asking the landlord to accommodate you so that you may enjoy the full use of the premises, and that you do need a slight rule change based upon your disability so that you may receive the full use and enjoyment of your residence. No magic language to make this. It doesn't even, and it must be in writing unless it is apparent. It must state what the accommodation is that you're requesting. Not that you're requesting an accommodation, but let's say you're requesting, I have mobility issues and I need a reserved parking space in the front row. You need to be specific, not just, I have issues getting around. It's, I have issues getting around, I am requesting a reserved parking space. There's a sample letter in the materials as well. There's a sample letter up on the screen. All right, now we've hit questions. All right, so I'm gonna start with the chat. I know I just threw a lot at everybody in a short amount of time to get to this point. Every time I've told a landlord about bed bugs, mice, wasp, mole infestation since moving here, they always tell me it is my problem to deal with and we will be charged extra if it isn't resolved by the end of the month if they have to step in. So why would I tell them if the tenant has to always fix it anyways? So you want to document that in writing, because if you're telling them verbally, and that's not, you're not invoking your protections pursuant to the warranty of habitability. So I would recommend making sure to put that notice of those issues in writing. If your landlord does not respond to those at that point in time, I would recommend seeking additional legal advice to see what options you may have available to you. What if the Windows secure devices don't work, but they are on the second floor? Do they have to still work? My current place has flat refused to fix the window or make them lock again. I would give them a written demand that the locks on the windows do not work. If they do not respond to that, your options would be to, at that point, you could potentially file a lawsuit seeking injunctive relief. That injunctive relief would be to have the locks repaired. Am I responsible for testing in mold if I experience new and severe illness from unit, or is it landlord? Landlord is responsible for the mold response timeline that was laid out on the slides earlier, is the best way for me to address that at this time. Tenant's responsible for the whole house water filters like osmosis water filters, refrigerator water filters, or well maintenance. So I don't know. It likely depends on how the lease is written. I would also need more information on what exactly we're talking about there, because there are 3 different types of analyses: osmosis water filters, refrigerator water filters, or well maintenance. What constitutes a comparable dwelling unit? Is an empty apartment considered a comparable dwelling unit? It very well may be. If we're talking about a 1-bedroom to a 1-bedroom, in my opinion, that seems pretty comparable. But if we're going from a 3-bedroom to an efficiency, I don't believe that's comparable. Comments in chat? I'm not really going to address those comments. How can we prove an oral threat from a landlord in court? I'm not going to sit here and pretend that that would be an easy battle to take on. Certainly witnesses. And then in a civil case, the burden of proof is going to be a preponderance of the evidence. So you don't have to prove that the statement was made beyond a reasonable doubt, just that it was more likely than not that the oral threat was made. All right, I don't hear any other questions I don't see any other questions in the chat, folks. I am not addressing the questions and conversations, which are stating that I'm wrong. Fine, I would love to get a second opinion. Any questions from the folks in person?
Yeah, so the Mobile Home Act, homeowners, fine, I understood that. But if you're renting both the mobile home and the land, is it the normal warranty of habitability, for instance,
Yes.
normal laws? Okay.
Yes, so, and folks online, the question was, if you rent a mobile home and rent the lots, you're not a homeowner, do the normal warranty of habitability laws apply? Yes, they do. If we think about that distinction, key differential there is homeowner, it's your home. Renter, not your home. So if in that situation, the Mobile Home Park Act likely does not apply, but general tenant protections would apply in that situation. I'm sorry, I forgot whose hands were up. Yes, ma'am.
I have 2 questions. Is mold and mildew the same thing?
I don't know. For purposes of warranty of habitability, I think mildew would be a little bit less than mold. I don't have the educational background to know what kind of the difference is between those two on kind of that cellular level. But the definition of, if we're thinking like mildew that just kind of accumulates on like maybe a tempered glass shower door or something like that, that may fall more into
The ceiling in the bathroom though, wouldn't that be mildew? See, I don't know.
I don't know, and I don't want to, that's one of those situations. That's a really good question. I've not actually run into that one before. Thank you.
My other question is, on some of those forms that you put up there that you had to fill out and mail in, can you not PDF those and email them, or doesn't that make it?
You can.
You can,
No, absolutely you can.
okay.
I would just recommend doing, one of the things with PDFs that I think, as we're doing more electronic communication to be leery of, is try to have some way to authenticate a signature on it, all right? Because then you run into kind of an issue on, well, did you sign this? No. My friend filled it out for me. Well, you didn't sign it, and now we have a problem because you haven't put your name on it saying this is true, and my signature is telling you that it's true. But yes, you can certainly email these documents as well.
You'd sign the bottom yourself, but then you
Absolutely, and you can scan it and
Yeah,
email it,
scan.
that's totally fine, there's nothing prohibiting that. I just provide those templates for folks to be able to use and to keep for their own records and use in the future.
Yeah, sure, okay. Thanks.
Sorry, yes, sir.
So what's income?
What's income?
Yeah.
Income is money derived from a lawful occupation. And I don't mean to be a smart aleck, I'm trying to recite the
I
definition.
understand.
So, I mean, look, it's money from your work. It's a voucher. Maybe it's child support, maybe it's alimony.
Social Security.
Thank you. Social Security, SSI, SSDI, maybe you have a structured settlement.
So, I gotta provide 2 times the rent. So if the rent's $1,000, I gotta show 2,000, right?
Mhm.
Okay. So is that take home? Is that gross rent? Is that before taxes? Is that before judgments? What is it?
It's, oh gosh, yeah, I would say it's likely before judgments.
I mean, I could have.
I mean, I'm very, so that's a
income.
very great that's a very great academic question. Everything I say would just be, I don't know, because I've not tested the statute to that level yet, sir. So, and what I mean by that is that when you're saying, is it net? I'm not sure. I'm not, because I have not yet tested a legal theory where we go to court and say, hey, this landlord violated the Rental Application Fairness Act because they denied me based on my net income when my gross income would be 200%. So I don't know, I don't have a firmer answer for you. This is a new law that went into effect, I believe, about 9 weeks ago. So there's not been any kind of case law from appellate courts, from trial courts that I'm aware of that have gone into depths to answer that type of question.
Can you ask somebody and let us know? I mean, there's legislators up there that wrote this stuff. What they have in mind?
I would, if I'm wagering a logical guess, I would think that we are discussing net income prior to judgments.
Can I just comment about the legislature? So new laws always take a while to kind of shuffle down and work out through the courts, or even, because when they're being made, these laws being made, there's all these different changes. So the portable screening, it's great, except for good luck finding a company that allows a renter to get the portable tenant screening. And I've been in conversations with 2 of the main legislators that wrote that, authored that. So finding that still hasn't happened because it's these companies that have to do it. If that made sense.
So the same thing about credit and credit scores. One slide you had said a landlord can't consider credit score?
Unless they are required to do so by federal law.
Okay.
And if the landlord is subject to the Rental Application Fairness Act.
And that's one of the new laws.
Yes, this is, that's one of the new updates in the last, from the last 9 weeks.
So credit scores cannot be a part of the discussion even.
Sorry, I'm not trying to be rude, I'm just gonna try to get back to that slide. It should not be. Credit score, lack thereof, adverse credit effects. The portable tenant screening report will include that, but the landlord's not supposed to take that into consideration unless they are required to for the purpose of federal law. Additionally, like we talked about, one way to think about that is also, well, how do I know if they've done that? They're required to give you that written notice of denial. All right, so If you're running into one of these issues where one of the updates is the reason that your application was denied, please contact CLS. I've not had an opportunity to really pursue a rental application fairness case, and I've been looking for one. That would be fun. Because this is, and again, this law is, the Rental Application Fairness Act has been around for some time now. However, there is yet to be a significant appellate decision regarding the Rental Application Fairness Act. So that additional clarity that you're asking me about, I wish I could provide that. I don't have it. The courts haven't provided it to us. And a lot of these are very
Subjective.
no, not subjective. Sorry, I'm just hitting the end of my words for the evening. I'm so sorry. I just kind of blanked. Untested, unchallenged is what I'm going for. So that clarification that you're seeking, oftentimes in the law, we get that clarification from courts through appellate decisions, and we just haven't had those yet.
So this portable,
Portable tenant screening report.
yeah, who makes that?
I don't know.
Okay.
I know that there are a couple of companies that do. Additionally, if you are working towards obtaining that report and along the way you think that maybe this company is running a scam, I would contact the Attorney General. All right, because this is a new law that's come into effect. The legislator that was one of the sponsors of this bill is a local legislator who was actually at our last event. She was able to speak on this subject much more eloquently than I, and I believe that video may be online still.
So Zillow, for instance, they have an application you can fill out. If I fill that out, does that mean that anybody that advertises on Zillow that would have to take that?
I don't know. And I'm saying I don't know because I literally just don't know how their system is set up. I don't know if that would qualify as the portable screening report because I've just not applied through Zillow. So I'm not familiar with their system or what information we're entering into it, sir. I'm not trying to avoid your question by any means.
I could add to that, so how it has been before this law was in order for those third parties to do the screening, it had to be initiated by the landlord. The landlord paid for it and it had to be initiated. The problem we're finding, because I talk to people all day, is that there's not ones that can be initiated by the tenant. Yeah. Or there's one that's $152 a person, which that's not saving. The whole idea was to save low-income folks fees.
So if I pay one landlord for doing an application, and I should be able to take that application.
No.
That's different.
You're not paying the landlord. You're paying a consumer reporting agency.
Mhm.
All right. So, you're paying, if, like you are paying the consumer reporting agency.
Name one.
Experian.
Thank you. Experian, Equifax.
Yeah, there's
Okay.
thousands.
But they only give me a credit score, and I don't have to have a credit score.
But sir, you're saying if I pay the landlord for that application, but that's not what we're describing. What you get from, let's use Experian. I don't know that Experian does a portable tenant screening report. You pay them for it. They provide you with the report, and then you take this report, and then you go and you give this report to all of the different
All the
landlords.
different people.
Right. So you're not getting this portable tenant screening report from a landlord. You're getting it from a third party company, and then you're giving it to all the other landlords. I will do my best to learn more about potential providers over the next few months in advance of the next presentation. But I apologize right now. I just don't have that information regarding the potential providers of that.
You ready? You done, or you got more, or did I ask more dumb questions?
I have another one.
Over time. We are over time.
Just one last comment on the credit score question. I think there's a lot of questions on that. And it's part of it, if you look at the statute, they expanded the definition of what's subsidized means. And I don't know what was going on in chat, but I have a feeling that's what it has to do. And we're also asking for clarification on that, not because we give legal information. We just want to be able to, we're getting that question. So a lot of these things are still being tested. I like that word. If that makes sense.
All right, folks. One last question here, and then we've got to end for the evening, which is late fees only accrue outside of 7 days past due because rent isn't late until 3 to 5 days. No, rent is late the day after it is due, but late fees can't be charged until rent is 7 days late. So with that, I want to thank everybody for coming out tonight. Thank you for your time and your questions this evening. I really appreciate it.
Thank you, Clinton. Thank you. Well, thank you from me also, everyone, for being here. Sorry we couldn't get through all of the questions. As you can tell, the landlord-tenant law can be complicated. And a lot of the resources that were shared at the beginning are ways that you can follow up on this. As was mentioned, some of these new laws will be kind of figuring out how they work as we go along. And at the city with our we have a website, a web page for housing help and resources. Wherever we know that those resources are viable and specifically help folks who are needing help with housing, we will list them there. And you can find that in our newsletter, and we'll be sending it out for everyone who signed up as well after this. And again, we'll share the video and also the slides, and also feel free to contact all of us if you have other follow-up questions. Thanks again.
Thank you.
Have a good night.